program today is more about things happening online. So obviously with things happening online, it facilitates a lot of convenience, right? Everything is faster, quicker. You just click a button, then Redmart delivers your food. Actually, I was going to tell Joyce that my Redmart delivery was just when she was speaking, so it's quite interesting. But it also facilitates then wrongdoings, right? Infringement, and also problems relating to jurisdictional limits. This might get a bit technical, but what I'm saying is that because you can put your creations online very quickly, people can also take and use your creations online very quickly and distribute it widely without first asking for your consent or seeking licenses, etc., through websites and file sharing networks. In the past, when most activities were done in person or it's brick and mortar, infringement is probably much more easy to recognize, and you can stop it more sort of efficiently. There were fewer persons and companies that were capable of simply accessing your information and your IP. In this current day and age, it's completely different, right? With social media, everybody is potentially a content creator and a publisher, and their material can be easily infringed on a broad scale. The other point that I wanted to make also is that given that there is an involvement of intermediaries like social media platforms, e-commerce platforms, like Lazada, and we mentioned earlier Instagram, Twitter, etc. These platforms, while again very beneficial to everybody, also increases the accessibility of content that's being published. So in some cases, these intermediaries can be seen to facilitate IP rights violations, which calls into question whether or not they should be held accountable, because they're just helping the users and the service providers or the sellers come together, right? They weren't in the business of getting infringing materials online or facilitating infringing conduct. But this is also related a little bit to what Joyce was talking about as to why Lazada puts a lot of effort in educating its users and its stakeholders on IPR issues. Just an example of a case, in this case of Calvin Klein and HS International, essentially it was just Calvin Klein suing 3 defendants in relation to this website called SG Buy For You. So to cut to the chase, SG Buy For You sources its goods from Taobao and does not store or manufacture the goods in Singapore. Taobao then just delivers the relevant goods to a warehouse in China. Then the operators of that website would facilitate the shipping of the products to a customer in Singapore directly. So the defendants in that case tried to say that we're not liable because we're merely intermediaries, right? We're just facilitating the drop shipping. In this case, it wasn't a final judgment. The final judgment is not reported. But in the one that was reported is a summary judgment. Essentially, at an early stage, the court was able to already see that the operator of the SG Buy For You website is liable, notwithstanding that they didn't actually hold the goods or promote the goods or manufacture the infringing goods, but they were liable for facilitating it. And that platform probably didn't have the protections like Lazada does, and doesn't have all the infrastructure that's set up to avoid that sort of liability. So something like a cautionary tale. If you ever want to set up a platform, you must be careful that you will also be liable if you facilitate infringing conduct. The difficulties, another issue with online infringement enforcement is that IP infringers will face issues when infringing conduct or your IP rights actually spread across different jurisdictions. There are minimum standards, as Paul mentioned, set out by various international treaties, and which basically say that if a certain country has signed this treaty, then they must all agree that their laws must meet a minimum standard in terms of IP rights protection, and they must sort of give like a reciprocal rights to the other countries that have signed a certain treaty. But while that sounds like, oh, then that's good, right? So all the IP laws and all the possibilities of infringement should be unified across different countries. But first of all, not every country is a signatory, and not everybody applies the same high standards when it comes to whether or not something's infringing or whether or not something constitutes an enforceable IP right. So the varying law and practices around the world that makes it difficult for businesses, which span different countries potentially, and it fuels uncertainty in legal outcomes. So you will think that, oh, in Singapore it might be good, but in Malaysia it won't work out. In China, even worse, don't even start talking about it. So how do you manage your business if your goods are in different countries and your registered trademarks, whatever, are listed in different countries? How do you manage that? By asking that question, I'm not saying I have the answer. I just wanted to flag that it's something that is difficult, something that you have to think about before you do go into business online. Another common issue is that in an online environment, I think Joyce touched on it a little bit, infringers are often shielded with a level of anonymity. So people are using monikers, hiding behind fake names, etc. So sometimes when you find that there is an infringing conduct, you may say, oh, okay, let's get a lawyer to go after them. But who are these people? You don't even know their names, don't even have email addresses, Many times the service providers might have that information, your internet service providers, but they may not easily provide that identity or contact information to you, especially since there are differences in privacy laws around the world. One thing is for sure is that the law, at least in Singapore and actually generally worldwide, this is not an issue that they are not, that the powers that may be, they are not blind to. For example, in Singapore, in the recent case of CLM and CLN, the Singapore High Court found that it had the power and jurisdiction to grant interim orders. Interim just means early preliminary orders to persons unknown. So if you don't know the identity of certain people who did some wrong. So this is not an IP infringement case, but it's just setting the stage for giving the court the ability to then give interim orders, things like freezing orders, which means they cannot move their assets, and injunction orders, which means they cannot continue certain conduct to persons unknown. Part of these orders can also include orders to intermediaries to provide information about these persons unknown. So you can start an action quickly, even if you don't know the full details of these people, as long as you can sufficiently identify them. In this case, this was in relation to cryptocurrency issues. The last point on this slide, our courts have also been flexible in allowing plaintiffs to effect service differently. So everyone might know, from watching TV, etc. Service usually, or some guy hands you a paper and they say you got served, right? So that's a very traditional, normal way of using physical service on a person. So that still is the standard, except that the court in Singapore have realized that actually you can reach people by maybe even better using social media, email, etc. So you can serve and commence proceedings and then bring those proceedings to notice of the person in question through email, Skype, Facebook, internet message boards, etc. I find that quite interesting and also a little bit scary, right? But if you don't do anything wrong, you'll be fine. So one may not always consider existing IP rights first before you start to run your business. Actually, I do think that you must consider not just market study, how much money you would make, whether you have the relevant consumer market, but you also have to consider existing IP rights in that same market before you start to decide on the key aspects of your business and what you intend to do. This is a very serious matter because if you fail to do that, it would immediately negatively impact the operation of business. And then money, time, and resources will be poured into to either fix that IP, change it so that you don't infringe on others, or you have to pull back everything that you've already done and then redo. And that is, basically wasting money and wasting time. That is putting aside the fact that obviously IP infringement can lead to legal consequences. The disruption to business operations is probably the biggest issue. One of the earliest things you can do to avoid the infringement of other people's IP rights is to do a bunch of searches. So it's similar to doing a market study before you enter it. So before you enter a market normally, or even before you carve out your own business idea, you would do the usual research to see, what is needed, where are the gaps, what are the pain points that consumers are suffering. So you want to try and address with your new business idea. It is now more important than ever that you also conduct searches on IP that is already out there. You don't want to find yourself deep in business development and planning and marketing especially, only to find out later that you have to unwind everything because what you were planning to do is potentially infringing on someone else's IP right. So what you can do are things like trademark searches, design searches, patent and domain name searches, as well as general market studies. And so a few points about enforcing your IP rights, right? IP litigation, as I mentioned earlier, potentially could be very expensive. So you got to think about the cost and the proportionality of it. As I mentioned, costs are high because the Singapore High Court has exclusive jurisdiction over registrable IP rights, regardless of the sum. Then you have to involve technical experts, especially with patents, maybe even copyrights as well these days. And then there's also, at the moment, really not enough IP, reported detailed IP cases for all the different technologies that are out there, right? Even in the very established jurisdictions like in Europe or in Japan, China, and UK, you can never cover, the law can never cover all the different technologies that are coming up every day. So potentially, people will have to figure out different ways to protect and enforce their IP. A good thing that has come up in the new SCJA intellectual property rules, so that's here, the Supreme Court of Judicature IP rules, is that they have now introduced an optional simplified process to resolve IP disputes that are smaller in terms of value that is being fought out, and also less complicated, where there are caps for costs that can be incurred, and ceilings for if you do a certain thing in the proceedings, there are already fixed costs that will be recoverable. So that's a little bit more helpful for parties who may not be, your big pharma companies, etc., but want to still try and enforce their IP rights. Okay, I'll skip that. Practical considerations when it comes to enforcing your rights, you have to weigh the cost and risk of litigation because it may not always make sense to initiate proceedings, right? One thing for businesses operating in an online environment is that not every instance of what they deem to be infringement will necessarily be vindicated. So you will have to think of other ways to fix the problem. So for example, earlier on, I spoke about domain names. So if you can't pursue the domain name squatter, then the alternative, instead of paying him $100,000 to get the website, use a different one, use your time and money to do more marketing to promote the slightly different domain name website, for example. So you just have to be a little bit more creative than just going straight to court necessarily.